Bill Henshaw here, Constitutional Crisis Channel, and I've had one of my correspondents on email I'm going back and forth with quite heavily here. Is getting interested in what I'm doing, and he made a real good point. And it said, gee, he was relatively new and didn't understand with these document packets, what you're supposed to do. And I said, that's a good question. I've been a little lax in my videos not to have covered that, so I'm going to make up for that here and tell you what you do. Now, this would be mainly from California, but pretty much it's the same procedure across the country. And it's even better because we're filing documents invoking federal jurisdiction. And I'm going to have a letter in both document packets that covers that. So you get it to the clerk of court, the executive officer of the superior court, whoever, and say, wait just a minute here. Or as Lee Corso would say on Saturday afternoons in college football, not so fast. We're invoking federal jurisdiction here. Therefore, your rules of court don't apply, your local rules don't apply, and you'll get a document from me that supports the fact that the federal rules of civil procedure don't apply either. We have a right to invoke federal concurrent jurisdiction. We have a right to invoke the non-statutory writ of habeas corpus, and they can't get around it. Simple as that. And some of the people there actually know that, and they're not happy about it. When you come in there, not our problem. But point is, you get the document packets, and with the original ones, the bill of particulars and the notice of denial of counsel and other documents, you can do one of two things. I personally prefer to mail my documents to the people they're going to. And that way, I go to the post office and I get a receipt for it, and I write exactly what it is on there. And I have those postal receipts I can later put into the hands of the foreman of the jury to prove I sent them. Whether they got filed or not, I'm not that interested in. Although if they don't get filed, that's Pandora's box, and I don't think any public servant in their right mind wants to go there. That said, you can go to the offices, and usually, as in California, the clerk of court's in the same building as the the DA, and you can do both at the same time. But I would suggest doing it with a witness or two, just in case. Now, I've had good luck over the years with clerks of courts, and I'm especially indebted to the one in Columbia, South Carolina, for doing her job. And I sent her a nice letter and said, what you've just done here is going to do more for your cause of civil rights than anything else you could possibly have done. Because clerks, when you go there, pretty generally file documents. That's their job. And we're going to get them to do it. So you go in California, most of what we're doing is with the traffic court. And they usually have separate clerks of court for traffic court. And that's where you go. You find out the address for the traffic court, quote unquote, and go to the clerk's office and file them. And I always take 2 full copies of the documents and title copies of every page of the documents that you have. You're going to have 5 or 6 of those, and tell the clerk that you want conformed copies. They've got a stamp file thing. They just for first page, stamp file, date, time, they sign it, and now that's officially filed. So you want conformed copies. And since you're there, hopefully with witnesses, you can then walk down to the DA and serve on them these conformed copies with your witnesses present, and you will have conformed copies of the title pages for your records. So now the record is set. And this is alarming because what they don't know is that with the record set like this, now you're set to go up on appeal and maybe get a favorable ruling from a higher court. And if that happens and it gets on the record, that puts them out of business across the board because it's good for all cases. It's binding precedent. Now, what these bastards don't appreciate is, I know for a dead fact, and you'll read it in my papers you're going to get, that the Supreme Court of the United States has said there's no right to an appeal in any criminal case. So therefore, you wouldn't think they would have these kind of concerns. But this is a system, after all, like I say, with civil quote-unquote rights. Sometimes they got to make it look good. And oftentimes, you'll have that happen. But in California, what they do here, and I've got a couple of examples of this you'll see in my paperwork, are unpublished opinions by circuit courts of appeal. Now, the unpublished opinions, from their point of view, in theory, you can't use them to support your arguments. I don't know where in the world they've come to that conclusion when you're getting opinions by judges that are paid from the public treasury to do their job, and we can't use them? Oh, someone's going to have to explain that one to me. And oh, by the way, I've never yet heard of an unpublished opinion by the Supreme Court of the United States, for what it's worth. But in any case, the point is, no matter how you do it, either by mail or in person with a witness or two, you then get your witnesses, if you do it that way, to do some brief affidavits, 2 or 3 paragraphs, probably will be sufficient, that yes, I was with my friend and I saw him give the clerk these documents, I saw him serve the DA with them. Simple documents. Because now you go into court, especially if you've done this early on, you go to the quote-unquote arraignment, and the judge says, how do you plead? And my God, you see this on Law and Order all the time. It goes on every damn episode. How do you plead? Not guilty, Your Honor. I didn't do it. Case over. Once you enter a plea, that's highly jurisdictional, which they didn't bother to tell you when you were in school, and they didn't tell me 50 years ago either. But now you're in a position to go into traffic court, hopefully with a witness or two there, too, with yellow legal pads. And you get up there, how do you plead? I stand mute. There are no valid charges before this court, and I'm not going to enter any plea. And you'll notice out here in California, and this is true in a lot of other jurisdictions too, the only pleas they recognize, guilty, not guilty, nolo contendere, which is no contest. The basic big deal there being that if you plead nolo, then people suing you civilly later can't come back and use it against you. And by the way, the first time I ever happened to have heard of this, long before I know what I know now, involved good old Spiro Agnew, the governor of Maryland, who was at the time vice president and forced to resign over some indiscretion he committed. And he gets to court and he pleads nolo in the criminal case, so they can't use it against him when they sue him later civilly. I didn't get all the big deal that was at the time like I do now. But those 3, and of course not guilty by reason of mental incompetence, that one's probably a subject matter for a whole other video later. Because these bastards do nothing but think we're incompetent across the board, except on election day. Other than that, they couldn't care less. They think we're incompetent to do anything without a damn license. And you will learn the definition of license later from Black's Fourth Law Dictionary, which the DA is supposed to tell you in the Bill of Particulars, and they never do it. I've never had one acknowledged in 4 decades. And it beats them across the board because you have a right to know nature and cause of the accusation, which is jurisdiction and venue, and the identity of the elements of each crime they have to prove. If they're not going to do that, what are they saying? They're saying, we don't care, you don't have any rights, we're going to come in there and convict you with the directed verdict of guilt, and you have no right to put on any defense whatsoever, let alone a meaningful and substantive defense. Why bother to have a trial under circumstances like that? It doesn't make any sense. And as I think I suggested on earlier videos, I think the estate of Joe Stalin would have a hell of a claim here for copyright infringement on their show trials in the 1930s. I mean, it's basically the same thing. So this is the point about how you get things done and how you serve papers. And once in a while, you might actually have to talk to a supervisor of the court. I've had pretty good luck with that. And in California, we have officers entitled executive officers of the superior courts. And the 2 that I've had dealings with have been very kind and very helpful and even respect a lot of what I do. And if you approach it the way I do, they'll do the same thing with you. And that, by the way, leads me to another point I hadn't thought about before I did the video. But when I approach local officials, for the most part, and this was true in South Carolina, where I was sitting there with my ass in jail for 5 months, I never got angry with them. Of course, I didn't confront them personally at the time, to be sure. But I never get angry with most of the local people because they don't know any better. And if you approach it that way, and believe me, I had all I could do to control the absolute volcanic anger I had back in Columbia, South Carolina, but I did it. Because I wasn't confronting the people that I want to let that out. If I ever get one of those in front of a jury, look out. I'm going to blow the roof off the courthouse. But this is, for the average people, they don't know. You have to give them the benefit of that doubt and do what I do. You send papers educating them on what the law is and saying, why aren't you operating within the confines of what you're supposed to be doing? That's a much better approach. Anger very seldom is the right thing to do, and especially when you don't have the background to do it. And most of you don't right now. I mean, come along with my videos and learn about what I'm doing and get some education about it. Yeah, then it might be appropriate in certain circumstances. And by the way, I extend this to most of these thugs or law enforcement officers, even the ones doing traffic stops, because they're not properly instructed. I have some issues about that I'm going to talk about on a later video, not in the group now, but that has to change. They have to be properly instructed, know the bounds and limits of what they can do. And for example, if that happens, then the traffic laws only get enforced against Microsoft, IBM, Bank of America, whatever, corporate entities. They're the ones subject to it, not you, not me. That's how it's supposed to work. And as soon as the cops get trained like that, most of this goes away. And then we get our government back who can pass laws. And the amazing part is they can do a fair amount of what they do actually in the California Vehicle Code, but not the way they're doing it. I can beat every damn statute on the book, and they know it now. I'm already 6-0 against the bastards, and haven't even been challenged. So I'm getting a little astray here. I didn't mean to do that. But nevertheless, this is what you do. You get your documents served and filed, and you sit back, especially if you've done it from day one. And then you're going to be in really good shape, and the case will get dismissed if you do show up for a trial date, quote unquote, just like it happened with mine. In the last case, my friend was in and out of court in 30 seconds. That's a record even for me. But this is how it works. And you just get this stuff done, and sooner, in fact, you start doing this and you get 3 or 4 of them rung up there, it may be that the next traffic tickets you get, that they won't even bother to file charges. What do they want to do that for if all they're going to do is dismiss it anyway? That's one of the goals I'm trying to reach here, but I would much rather get a decision on the record, putting the DMV out of business. And I'm working on that hot and heavy every day, and if and when that happens, not only will you hear about it, you may not hear about it from me first, because that's going to go on the internet. Constitutional crackpot shuts down DMV. I'll take it. And that's the direction I want to take you into, and give you a good, healthy shot of self-esteem here and know how to deal with these bastards. Continuation of my video on serve and file. What I meant to say that I omitted accidentally was that my procedure is, in addition to not getting angry with the public servants that we do deal with face-to-face on a day-to-day basis, is that my program, what it does is challenges not so much the exercise of power, and trust me, some of these powers are so far beyond what government can do, you won't believe it, but I challenge the qualifications of the people that are in the position to exercise the power. That's what sets my documents and my positions apart from anyone else. I don't think anyone else is doing what I'm doing. That's state versus territory. Because if they're in a territorial government, they're not qualified to hold any offices of honor, profit, and trust in government. And you start raising those kind of issues, that's like turning on a light in a kitchen full of cockroaches. And away they go, because they have no way to deal with that. They don't know what the hell you're talking about. They're too embarrassed to know what you're talking about. And they got to be frightened to death that if that case goes to the Supreme Court and you win, their life is over. Because they've committed treason, whether they knew it or not, isn't our problem. They didn't get taught in school either, but the difference is they've taken an oath to preserve, protect, and defend this Constitution. If you don't know what the hell you're doing, you have no business being in that position. How simple is that for a jury to understand later if it comes to that? So that said, this is what separates me from just about every other person out there. What I'm doing, I haven't seen anyone else do. And the record I have speaks for itself, 20-0 right now, and getting better every day. I want to help you to do the same thing. Now, continuing the serve and file video, it occurred to me that I should have mentioned there's a document in there that when you go into court and they're going to say, okay, you have a right to counsel, which we both know that you don't have, fine. We'll play along, despite the fact we're going to file that notice of denial of counsel. And you're going to go to a defense attorney, who knows, maybe the public pretender, and go with a witness or two and sit down and bring the papers in that will be stamped, filed by the clerk, and say, these are the issues I want to raise here. They are structural jurisdictional errors. And I need somebody with a sound legal education who knows how to do this better than I do, noting that I wasn't taught any of this at all in the mandatory public school system. I have no way to be effectively able to do it. So I'm going to rely on you to do this. So you then offer them this document. If they're going to say, I'm going to refuse to do it, you certainly want them to tell you why that they're going to refuse. But more importantly, you give them this document that's in the packet that's for the attorney to sign, saying that he will not press the issues that you want to present in the traffic court or wherever else it is that you are. And trust me, most of the attorneys in their right minds won't do this, because the issues they raise, not only they put the DMV out of business for most of what we're talking about here, but the notice of denial of counsel directly challenges what I call the malevolent monopoly of the State Bar Association. And that's an irreconcilable conflict of interest for any member of the State Bar to even consider raising issues like that. I mean, who knows what they get behind the scenes if they ever anticipate somebody's going to come in the office and ask a question like this. They're not going to do it. And yet we have the right to challenge jurisdiction at any time. When you get this issue to the Supreme Court, there's only one possible way they can rule on it, and that's in our favor. And on the other side, they know that as well as we do, and that's why a lot of your cases go away and they say cases dismissed in the traffic court, see you later. And or if it goes up on appeal with the writ of habeas corpus, it comes back down quietly with the case not even decided on the record, and the trial court is ordered to dismiss the charges and get rid of the case because they cannot afford to have issues like this go up to the higher courts. They're way too dangerous, and it isn't just your case. That's the power we have. And that's the point of this document. You get the attorney to sign it or refuse to sign it, which in some ways is even better. Now you're going to have witnesses that can put in a 2-paragraph affidavit. Yeah, Joe Blow went to the attorney here and he refused to, sign the document, but he also refused to identify why he would not present the issues. That's another Pandora's box that they cannot possibly want to open. I mean, this is the power plus that we have. Once you understand this, we have it, and they don't. That makes life so much easier, and it isn't just in traffic court either. Continuation of serving and filing video, and the bottom line to all of this is, and maybe you want to go to 2 or 3 attorneys to be on the safe side, but even if you get only one of them that signs a document like this, which makes it easier, but if they don't, I think the same argument exists. You go into court and say to the quote-unquote judge, or as I call them, black robe bastards, I've tried to engage services of counsel, effective assistance of counsel, but Joe Blow, attorney here, refused to sign the document. Therefore, I've been denied assistance of counsel at all, and I can't possibly get a quote-unquote fair trial in this quote-unquote courtroom. Case dismissed. Simple. Thank you.